Counsel, you may begin.
Mr. Chief Justice, and may it please the Court, my name is Gabriela Figueiredo and I am representing the Respondent. I am asking the Court to hold that the state's denial of the petitioner's application for concealed carry license is for self-defense. Did not violate the Second Amendment. I will first be presenting the summary of argument. The Second Amendment is for a well-regulated militia and for the rights to self-defense in the home. Therefore, New York's proper cause requirement for a concealed carry license does not violate the Second Amendment. The New York's requirements does not infringe on the right to keep and bear arms. The Second Amendment helps Congress to make sure that the militia is properly equipped. The limits of the Second Amendment protects the right for self-defense in the home and for a well-regulated and equipped militia. The term arms includes weapons ranging from muskets to stun guns. The court should use intermediate scrutiny. The court should also consider public safety by regulating firearms. The court should look at early American history and early modern history. There is a difference between openly carrying a firearm and concealed carrying a firearm. And the facts. So to the facts. Robberies were recently occurring in Robert Nash's neighborhood. He had recently taken part in a gun training course. Mr. Nash had a clean criminal record. Therefore, he applied for a concealed carry license and New York in September 2014. His application was denied by the government because of the lack of specific need for a concealed carry. Brandon Kosh, also from New York, applied for a concealed carry license. Similar to Mr. Nash, Mr. Kosh's application was also denied by the government because of the lack of specific need for concealed carry. Mr. Nash and Mr. Kosh sued the superintendent of New York State policy. They challenged the requisite proper cause of New York penal law. This law overall states that openly carrying handguns is banned in New York. Although, if someone desires to carry a handgun outside of the home and isn't in the employment categories, then that person has to prove and show that they have a specific need to have concealed carry outside of the home.
Okay, so counsel, what does the Second Amendment protect?
Your Honor, the Second Amendment protects the right for self-defense in the home and for the right to keep and bear arms for the sake of the militia. The Second Amendment states that a well-regulated militia being necessary to security of the free state, the rights for the people to keep and bear arms shall not be infringed. This clearly shows that the Second Amendment protects the right to keep and bear arms for the sake of the militia, as stated by the court in United States v. Miller. In Miller, it says, the sentiment of the time strongly disfavored standing armies. The common view as the adequate defense of the country and laws could be secured through the militia, which were civilians, primarily soldiers on occasions.
So why did the framers include the Second Amendment in the Bill of Rights?
Your Honor, the Second Amendment helps Congress to make sure the militia is properly equipped. Article 1, Section 8 explains how Congress provides for the defense of the nation by regulating the militia, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repeal invasions, to provide for organizing, arming, and disciplining the militia, and for providing such part of them as may be employed in the service of the United States, receiving to the states, respectively, the appointment of the officers and authority of training the militia according to discipline prescribed by Congress. United States Constitution, Article 1, Section 8. This court explained in United States v. Miller, which says, with obvious purpose to assure the continuation and render possible the effectiveness of such forces, the Declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. The founding fathers were afraid of standing armies. An example of this is found in John Adams' essay of man's lust for power. Power is a thing of infinite danger and delicacy, and was never yet confided to man or any body of men, without training their heads. Was there ever in any nation or country since this fall a standing army that was not carefully watched and controlled by the state so as to keep them in pointed, that did not vanish, plunder, um, massacre and ruin, and at last inextricably enslave the people. Adams' statement explains why the founding fathers wanted the militia to be well equipped. Another example of the concern is that New York's ratification of the Constitution with proposed amendments. The Second Amendment, that standing armies in time of peace are dangerous to liberty, and oath not to be kept up, except in cases of necessity, and that at all times the military should be under strict subordination to the civil power. This is an example of why the founding fathers wanted Congress to regulate the militia.
So, counsel, what are the limits of the Second Amendment's protection?
Your Honor, the limits of the Second Amendment protects the right for self-defense in the home and for a well-equipped militia. The Second Amendment protects the right for a well-regulated militia and an official group of civil men. This court explained in United States v. Miller that the founding fathers put the Second Amendment into the Constitution so Congress could regulate the militia, without obvious purpose to assure the Constitution and render possible the effectiveness of such forces. The Declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. Second Amendment also protects the right for self-defense in the home, said in District of Columbia. Heller also explained that there is a need to look back to history on gun regulations. On page 2, the brief of Professor of History and Law for the respondents explains how in the Statute of Northampton there were restrictions for armies in 1328. No man shall come before the king's justices with force and arms, nor to go, nor ride armed by night, nor by day, in fairs, markets, nor in the presence of the justice or other ministries, nor in no part elsewhere. According to this quote, it clearly states that there was a regulation of arms depending on where someone went, specifically in public areas. This supports New York's regulating arms in certain locations. In the late 1600s, New Hampshire, New York, and Massachusetts prohibited people from carrying arms offensively in public areas. In this tradition, New York's law is constitutional because it follows historical precedents. Also mentioned in Miller, the militia, civilians, primarily soldiers, on occasions. The militia is not a group of sluggish people, but of.
So it's actually counsel. Let's actually talk about that. So what is a militia, and why did the framers refer to it in the Second Amendment?
Your Honor, as mentioned in Miller, the militia, which were civilians, primarily soldiers on occasion, which a militia is not a group of sluggish people, like I said, but of civilians willing to serve their country. The preamble to the Second Amendment mentions service in a militia as reasons why civilians or citizens have the right to keep and bear arms. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
So, counsel, what weapons does the term arms include?
Your Honor, the term arms includes weapons ranging from muskets to stun guns. This court in Miller explained that the Second Amendment refers to arms that were of the kind in common used at that time, stated from Miller. This refers to arms used in that specific time. In Caetano versus Massachusetts, this court was also explained arms included weapons that are used currently, such as a stun gun. The definition of the verb keep means to hold.
So let's also talk about what is the difference, if any, between the verbs keep and bear, counsel?
Your Honor, the definition of the verb keep and bear arms means to hold or to retain in one's power or possession, not to lose or part with it. As to keep a house of a farm, to keep anything in the and to keep anything in the memory, mind, or heart. So that is said from the Webster's Dictionary from 1928. The definition of the verb bear means to carry, to convey, to support and remove from place to place, as they bear him upon the shoulder. The eagle beneath or beneath them on eagle on their wings. Webster's dictionary says it on the same year, so 1828. As written earlier, there have been.
So, counsel, can I interrupt? What is strict scrutiny, intermediate scrutiny, and rational basis review?
Your Honor, strict scrutiny is used when a court finds that a law infringes a fundamental or constitutional right, such as the right of freedom of speech or equality under the law. In this case, the court should use intermediate scrutiny. Intermediate scrutiny is used by the court when a law violates an important right. In the order to pass intermediate scrutiny, the government needs a good reason. In this case, New York has an important government interest, public safety. New York still allows certain people to carry a firearm under the circumstances that they have a good reason. Also, New York allows self-defense in the home. The rational basis test is a normal standard test of a review that courts apply when considering laws that don't violate the Constitution, the constitutional right.
So, counsel, let me just ask a follow-up question. So, how should the court consider the public safety implications of licenses to carry firearms?
Your Honor, the court should consider public safety by regulating firearms. The court should consider that there already exists a license to carry a firearm for hunting, target places, nevertheless in the home for self-defense. It is important to have public safety. It should be the government's job to protect the public. And an example of this is regulating firearms. In the Declaration of Independence, it declares that the government should protect life, liberty, and the pursuit of happiness. The preamble in the Constitution declares that people should be at ease. The government's job is to ensure domestic tranquility. The government's job is to ensure life and peace to the public. Restricting firearm laws is an example of ensuring life safety to the public.
So, counsel, how should courts determine if a gun control regulation is considered longstanding?
Your Honor, the court should look at early American history and even early modern history. As mentioned in Heller, the court should not change longstanding laws. Criminals should not own firearms, nor should mentally ill people be allowed to own a firearm. There are also laws prohibiting that the right to carry a firearm is sensitive in sensitive places, such as airports, mentioned in District of Columbia versus Heller. In the end, there is a long-standing tradition of states requiring that they should have a good reason to carry a firearm in public. In the 1930s, Pennsylvania, North Dakota, South Dakota, Washington, and Alabama passed the USRA Model Act. This allowed an applicant to be able to have concealed carry license because they were being threatened, mentioned in professors of history and law. New York's law also allows people to have concealed carry if they have a good reason, such as if they were in danger of being threatened.
And then this is my last question. Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Your Honor, there is a difference. There is a difference between openly carrying a firearm and concealed carrying a firearm. The court shall consider that my bad, Your Honor. There is no difference between openly carrying a firearm and concealed carrying a firearm. Openly carrying a firearm allows the gun owner to carry their firearm visible to other people, such as strapped on their belts. Concealed carry allows gun owners to conceal or hide their weapon well enough so that no one else can see it. So an example of that would be such as completely tucking it into your an article of clothing, or just keep it like in a backpack or in a purse. Ultimately, owners would still physically be carrying a firearm, as mentioned in Pruitt versus Court of San Diego. In principle, there is no difference between a law prohibiting the wearing concealed arms and a law forbidding the wearing, such as are exposed. And if the former be unconstitutional, the latter must be so likewise. The government's job is to ensure life and peace to the public. How is this able to happen? If people are worrying about the person next to them, if they have a firearm, and if they're going to use it for the better or for the worst.
All right, thank you, counsel. Counsel, you can wrap up your arguments.
Your Honor, it is for the reasons that we pray that the court finds in favor of the respondent and holds that the state's denial of petitioners' applicants for concealed carry license for the self-defense did not violate the Second Amendment.